Let's go on the record on cause number DC 18-18484, Mabanta versus Echt. Council, make your appearances.
Walt Herring, Your Honor, is here for the defendant.
Let's do that. Usually we start with the plaintiff and then we go to the defendant. So just why don't we have plaintiff's counsel announce first and then the defense counsel.
Nicole LaBeouf of LaBeouf Law for Dr. Sheilane Mabanta.
And Walt Herring is here, Your Honor, on behalf of the defendants, Dr. Echt's practice, PA LLC, and Dr. Echt himself individually.
Okay, let's go ahead and proceed, guys.
Yes, Your Honor, this is summary judgment motions brought by the defendant in this case, the defendants. Very briefly, it's a dispute between Dr. Mabanta, who is an employee of Dr. Echt's practice. It was the cancer center here in Dallas, a small practice with several offices, including one in Decatur, which is where Dr. Mabanta was officed and practiced. Dr. Mabanta was an employee of the practice from 2013, August 2013, until January of 2019. She had signed an employment agreement and her employment was pursuant to that. Dr. Echt is the owner of the practice, although he did sell a portion of that practice very late in October of 2018 in this matter. Dr. Mabanta has brought claims essentially for breach of the employment agreement. She has claimed that she wasn't paid pursuant to the employment agreement. But in addition to breach of contract claims, she brought some equitable claims, quasi-contract claims, quantum merit, promissory estoppel, and unjust enrichment. And she brought a fraud claim. We have moved for a summary judgment on traditional summary judgment for her attorney's fees claims and for her quasi-contract claims. And we have moved today for a no evidence on her fraud claim. And I think it would be good if we address these one at a time, do the attorney's fees first, and I'll let Ms. LaBeouf answer. Then we can do the quasi-contract claims and let Ms. LaBeouf answer. And then we can do the fraud claims and let Ms. LaBeouf answer.
I think that's a good way to do it. And I've read all of the stuff on the attorney's fees. And so essentially the argument is that she can't recover attorney's fees because you guys are I can't remember, it's not an LLC. What is your entity?
Well, we were a PA, a professional association for most of this time. It did convert to an LLC 2 months before she filed the lawsuit. But for the practical purposes, we can treat them the same, the PA and the LLC. It's whether they're a corporation under Chapter 38.
And I will say I've read the case law on this. I absolutely 100% disagree with the Supreme Court and Court of Appeals previous decisions on this, but I do have to follow the law. And so I don't know how you get around it, at least as to that entity. So Ms. LaBeouf, what is your response?
Yeah, so the entity has changed at least 3 times since the entry of the employment agreement. It was a professional association at the time of the agreement, and it remained a professional association throughout almost the entire 5 years of Dr. Mabanta's employment. We can find no case that says that 38001 does not apply to a professional association. And we've cited to you, Judge, the portions of the Business Organizations Code that says professional associations are treated like corporations. So just because you later say, well, now we're going to be a PLLC or an LLC, I don't think you get to avoid the effect of Chapter 38. And that's the one entity, Judge. We're just not finding any cases.
Ms. LaBeouf, though, what did you sue? Did you sue the LLC or did you sue the professional association?
We sued the PA, and then it's now known as currently Texas Oncology Care, but we named the PA and Gregory A. Echt, MDPA, and then all the various names that it's had since.
Okay, interesting. Mr. Herring?
Sure. The cases that plaintiff points to in their response, or the Business Organizations Act, that's true. The statutes themselves say in those cases that we're going to treat this for purposes of this statute, we're going to treat a professional association can be treated just like this corporation. But that's not the issue here. That's irrelevant. The relevant point here is chapter 38, and chapter 38 doesn't say that. Chapter 38 doesn't say we're going to treat a professional association as a corporation. And as we all know, you can only recover attorney's fees if the statute allows it. And she's asking for these attorney's fees under chapter 38. And the enabling statute for a professional association specifically says a professional association means an association as distinguished from either a partnership or a corporation. The enabling statute itself says this is not a corporation, it's a professional association. And I'm with you, Your Honor. I've been on the bad side of this myself, where I can't sue for attorney's fees because I'm not a corporation. I'm not suing a corporation. So the law has recently changed. It's going to change, as we know, as of September 1st. It's now you can sue and receive attorney's fees if you sue an organization. And an organization is specifically defined now as including an association, along with a long list of other things like a limited liability company, et cetera. So as of September 1st, suits filed after September 1st, you're going to be able to sue an association. So, but we're not in that yet. And this case was filed 3 years ago. We are in that time of the law where you don't get attorney's fees if you don't sue a corporation. And she hasn't.
Judge, Chapter 301 is not an enabling statute for PAs. Chapter 302 actually addresses the details, certificates of formation, bylaws, governance, and it's Chapter 302 that states that PAs get treated like corporations, like for-profit corporations. Chapter 301 is a very short statute in which there's a discussion of who can own these professional associations, depending on what they do, whether it's an individual or a professional entity or both. In that Chapter 31, there's a distinction made about what is a professional association versus an individual, et cetera. But the Chapter 302 that governs professional associations says they get treated like corporations. We don't have guidance on this.
But that's 302, Your Honor. That's not Chapter 3.
Can I make a suggestion before we get too far down the road on this? And again, this is, you know, if it was up to Judge Hoffman, I think there's no reason to treat this any differently. I think the decisions that were made to change what was longstanding law that allowed you to recover attorney's fees against an LLC and other corporate associations, corporate or other entities, you know, the fact they changed that was kind of mind-boggling to me. And I'm glad that the legislature fixed it because it made absolutely no sense. But that being said, I have to follow the law. So what I would suggest, that if we can't reach an agreement, we can kind of go a different route. But what makes sense to me is this may be kind of an unresolved issue. And so what I would propose we do, again, this isn't an order, it's just a suggestion, is that is this going to be a jury or non-jury trial?
Jury.
Jury. So maybe what we do is we have so we don't have an issue. Let's say that Ms. LaBeouf is right and that professional associations, for whatever reason, can recover it. You can recover attorney's fees against them, even though you can't against LLCs. Again, it's. I feel like we're kind of Alice, what is in the Looking Glass or whatever, where you're just kind of down this insanity of this whole line of opinions that don't make any sense, to me at least. What if we did this? We have the jury decides all issues. Let me decide the issue of attorney's fees. I'll make a finding as to the amount of attorney's fees, but then say we're not going to recover them unless there's some cases that come up in between. And then if Ms. LaBeouf wants to appeal that decision, assuming that there's a predicate finding that would allow her to recover attorney's fees, if she's right, at least she would have the evidence so we don't have to retry it again. And if she's wrong, which I unfortunately I think she probably is, not that she's wrong, but I think the case law doesn't support that decision. How do y'all feel about that approach so that we can have the evidence that we need to, if the Court of Appeals makes some distinction and says you can recover against professional associations and not LLCs? Does that all make sense, that idea?
I think it makes sense. I'd rather try it once than twice, so.
Mr.
Well,
Hare?
Your Honor, well, of course, I would rather have what I believe is the law placed here, but if we're going to do it that way, I would think that should have the attorney's fees evidence that you're talking about after the jury verdict on the other.
Oh, absolutely. That's exactly what my proposal was. Do it after the jury verdict. And again, this is not an order. It's just a trying to practical suggestion. I've done this in many other cases, not for this reason, where the judge decides to issue the attorney's fees after the trial's over. I'm happy to do that. I think that would make the most sense here. But again, it's not an order. It's just a suggestion how to deal with this issue.
So you're suggesting a bifurcated jury trial, or
No, not a. I mean, there's a variety of ways you could do it. What I was suggesting was that that we both agree that if there's a requisite finding, the court will hold a hearing and make an order as to the amount of attorney's fees. But then I would do, unless again the law changes, but then I would order that the attorney's fees would not be recoverable. Again, assuming that there's no case law in the interim that clarifies this issue, and then say you'd have a finding as to the amount, so that if you go up on appeal and you're right, then you get that amount, and if you go up on appeal and you're wrong, then you know what I mean, just so we have the evidence, as opposed to if I don't do some kind of finding. Because the other option is I just grant the summary judgment, and then if I'm wrong, then you appeal me, you come back, and then we may have to retry part or all of the case. And that doesn't make a whole lot of sense to me. But I'm just trying to do this in a practical way that would save everybody time.
I see. I think I understand what you're saying, Your Honor. So rather than having to come back, if the law is that you can recover against a PA, which we don't think it is, but if it is that, we might as well go ahead and have the evidence now in front of you, so we have that for appeal purpose. Not
now, but after the judgment. If there's a judgment and she recovers on the judgment that allows her to get attorney's fees, a claim that allows her to get attorney's fees, then we would hold an evidentiary hearing, and then I would rule, assuming there's no change in the case law, that she can't recover, but this is the amount if she could.
We'll have that in the can then. That's fine with me. We should also do it for our attorney's fees as well, Your Honor, because we are also claiming attorney's fees. We've sued for breach of contract. We think we overpaid Dr. Mabanta. It's not much, but we think we overpaid her. So we ought to do both attorney's fees.
That's fine with me. Although there's the same issue in that, or if you're just suing Mabanta.
No, because she's an individual and I get to recover. This is a weird situation where I can recover attorney's fees against her and she can against me, which is weird.
Yeah. Which shows why these decisions make absolutely no sense. But that's just me. I'm a trial judge. I have to follow the Court of Appeals, so in the Supreme Court.
And I have to represent my client, Your Honor. Yes, I understand.
No, I get it. I get it. No one's faulted you for that. Are you agreeable with that, Ms. LaBeouf?
I think, as I understand it, Mr. Herring is saying he would present his fees in the same manner to the court only after the jury verdict.
That wasn't, I mean, if he's willing to do it, I think that makes perfect sense.
I'm willing to do that too.
I think that's an excellent way to approach this, but I'm not going to force you to do it.
Ms. LaBeouf and I, why don't we talk about this, Nicole? But I'm in favor of this idea if we're going to do it this way, at least now.
Yeah, just putting all the fees to the end, that's fine. All right, we'll talk about it, Judge, but I think if we do them all at the end, that makes a lot of sense.
So why don't we do this? Why don't you guys handle this via Rule 11? I think that might make the most sense. I don't want there to be any type of implication that I've and if you change your mind and you say, look, because what I'll do if you change your mind is I'll just grant summary judgment, and then you can follow reconsideration if there's some kind of case law that comes up. But I think it's in your interest, Mr. LaBeouf, to not do it that way, and really in his interest too. Just would save time. So, and again, of course, we may not even. I mean, this may not even happen because you might settle, or you may not recover on the requisite causes of action that will allow you to do this. So. Okay, guys, what's the next issue?
The next one is going to be the quasi-contract claims, and they are the plaintiff has brought unjust enrichment, quantum merit, and promissory estoppel. The case law is clear on that each of those claims is equitable but a quasi-contract claim. The unjust enrichment claim, the plaintiff has pled, and this is in her amended pleading, that artificially lowering the income by incorrectly calculating compensation and bonuses in accordance with the employment agreement. That's in paragraph 29 of the amended complaint. On the quantum merit claim, she claims that she should not be, that the practice and Dr. X should not be, no, I'm sorry, it's just the practice. Quantum merit's only against the practice. Quantum merit should not, the practice should not be unjustly enriched by breaches of the employment agreement. That's paragraph 30 and of the amended complaint. And a promissory estoppel claim is the promise to compensate plaintiff in accordance with the employment agreement. That's the promise. We didn't follow through with the promise as compensation to plaintiff in accordance with the employment agreement. That's in section 31. The cases are clear also, Supreme Court cases, numerous of these, that if there is an agreement, in this case, an employment agreement, that covers the quasi-contract claims, then they are brought inappropriately. That the contract itself is going to be what controls here. And all of those three claims, the unjust enrichment, the quantum merit claim, the promissory estoppel claim, as she has specifically pled them, rely on the employment agreement. And this is a breach of contract claim, and you don't get to bring those quasi-contract claims. Again, the Supreme Court in the Hill v. Shamoon case, and there's 2 or 3 others, all from the Texas Supreme Court, have said you may only recover though under the contract claim. The contract is there. On the unjust enrichment claim, the plaintiff in response has given us some cases where she claims unjust enrichment has been allowed when a contract is brought. Indeed, those cases do say that, but what the cases say is those are for overpayment cases. Where I've overpaid on a contract, I can then bring an unjust enrichment claim to recover my overpayment. That's not a breach of contract claim. That's an overpayment claim. And the cases are very clear on that. It's not, as the plaintiff says in her response, these cases don't talk about a fraudulently retained benefits, which is what she's trying to claim here, that because these benefits were fraudulently retained by the practice, that she can recover them. That's not what the cases she cites say. It's an overpayment is what they are allowed to bring back. She's not claiming we overpaid her. She's claiming we underpaid her. And that makes sense in this case, Your Honor, because if it's an overpayment, any breach of contract claim, you could then bring an unjust enrichment claim if it was an underpayment, because if I retain the benefit, if I'm the person who breaches and I retain the money because I don't pay you, well, you can't bring she's saying I can bring an unjust enrichment claim for that. That doesn't make any sense because it's covered by the contract. This case, she's saying Dr. Eck, or actually the practice, excuse me, the practice didn't pay her enough. So that's some sort of fraudulent retained benefit that she can then recover this unjust enrichment claim. But as I just said, the cases don't say you can recover a fraudulent retained benefit. They're recovering an overpayment. And she's not alleging we overpaid her. On the quantum merit claim, it's unclear how this is not covered by the contract. She agreed to a specific compensation. She's saying that, well, you didn't pay me that compensation, so now I should be paid what my value was, a quantum merit kind of blade, some sort of agreed value we're going to agree to in the future now, but the value of my services. Well, no, that's the contract itself. The contract itself controls that. She agreed to that payment. says we didn't pay her the right amount under the contract, but that doesn't entitle her to a quantum merit claim. Finally, on the promissory estoppel claim, the cases she cites for the promissory estoppel are only available if the claim is not covered by the express contract. All the cases cited by the plaintiff in response say, yes, you can recover on a promissory estoppel if it's not covered by the contract. Well, here it is covered by the contract. In fact, I think of the 2 or 3 cases that plaintiff cites as supporting her promissory estoppel exception, they all found that no, this is covered by the contract. This is not a promissory estoppel that you can recover under. Because
Mr. Herring, I've had a number of trials where we've submitted these equitable claims as alternate grounds if the jury finds that there's no contract or the claims aren't covered by the contract. Why wouldn't we do that here? I agree that you usually can't recover on the equitable claims and on the contract.
I don't think anyone, I'm sorry, Your Honor. I don't think anyone's disputing that there's a contract here. We're not disputing that there's no contract. We're saying we complied with the contract. She's saying we didn't. So these quasi-contract claims should never come up because there's no dispute about there is a contract in place. We believe we complied. She doesn't. That's the dispute here. We think we paid her correctly. We think we overpaid her.
Thank you, Judge. These arguments are based on an erroneous reframing of Dr. Mabanta's arguments. She was brought into the practice specifically to build up the Decatur Clinic, and unbeknownst to her, Dr. Eck was already shopping his entire practice for sale. She was not told that. She was never once paid according to her contract, and we've brought claims on 3 basic fraud grounds, and one was for inducing her to sign an employment agreement in a physician recruitment agreement, which meant that the hospital, Wise Regional, paid for her salary while they built the practice and while Dr. Eck siphoned away the profits that should have gone to her. Secondly, that she was induced to remain under a first-tier compensation structure that should have expired after 2 years and not moved to a second-tier structure. And then she wasn't paid under either. She was paid under this Frankenstein mismatch of the two. And that's why it's very important we have quantum merit as an alternative, and it's been pled in the alternative. And that is that there was some other agreement made that also wasn't kept, and she continued to work and she continued to be paid incorrectly, falsely, while money was siphoned to Dr. Eck and while they built the practice so they could sell it. Third, that she was induced to bill and code while Dr. Eck got the benefit of her billing and coding and not her. And so under quantum merit, it is an alternative to the contract claim. There is evidence, and the jury will hear it, that at the end of that second year, she was told, oh, you're not hitting your numbers. Let's keep you under the first payment scheme, which they'd never followed, unbeknownst to her, and then they didn't follow it still. And so we need that as an alternative should the jury say there wasn't a contract for this. Y'all we're stepping out doing something completely different. Promissory estoppel, again, promises made outside the contract. This representation that you're not going to get paid the way you'd like to get paid, we got to do something different, means that we pled in the alternative. And then under unjust enrichment, Judge, there were benefits obtained by fraud and the taking of an undue advantage as an alternative to the contract, including the fact that there were promises made outside the contract. We want you to bill and code. We want you to keep thinking you're getting paid under these CPT codes. She wasn't, Dr. Eck was. That's unjust enrichment, and that's not a subject of the contract. So we would ask, Judge, that all of the quasi-contract claims remain as matters that go to the jury, and because there's good sufficient evidence for each.
May I respond briefly, Your Honor?
Right.
That's a mishmash of convoluted, in many cases, inaccurate statements that don't really make much sense when taken together. It's not true that when she signed this employment agreement, Dr. Eck was already selling the practice. The testimony has been in this case, and this really is not really for a discussion today, but he started to try to sell the practice a year or more after the employment agreement was signed. He wasn't trying to sell the practice immediately when she signed or before she signed. The fact that he allegedly, the practice siphoned away profits that should have gone to her. She is under an employment agreement. You don't siphon away profits that should have gone to her. She's being paid under the employment agreement. Now, a portion of her employment agreement says you're going to be paid a percentage of the Decatur Clinic's profit, but still, that's a breach of the employment agreement if she's not being paid a percentage of the Decatur Clinic profit. That is a breach of the agreement. It's not siphoning away money doesn't mean that you don't breach the agreement. That fact that she was paid outside, they were doing something completely different, and she was paid outside what she was supposed to be paid, as Ms. LaBeouf just told us. Yes, if that's true, that's breach of contract. That's not some sort of equitable claim. If we weren't paying her, if we were siphoning some money off, or if we were trying to do something under codes, we didn't bill her coding, then okay, if that's a breach of contract claim. So all of these things that she's trying to say are outside the contract, they all relate back to the contract. And let me say this too. Some of these claims, as Ms. LaBeouf just said, that we weren't billing her codes correctly, or we didn't bill for codes that she was asked to bill. We would have made money from that too. So these codes that she's talking about were split percentages of profits. Some of them would go to the doctor for a professional split. Some of them would go to the practice as a technical split. But for all of these codes, we would have benefited from it. We would have benefited from those payments. So what she's trying to say, which doesn't make much sense to me, is that we were taking money away from us so we could take money away from her. But even if we were trying to take money away from her, that's still a breach of the employment agreement and doesn't give rise to equitable claims. They are claiming all of this is she wasn't being paid under the employment agreement. It's clear from their pleadings. Thank you.
I'll tell you how I generally handle this issue, because it comes up not infrequently, is I usually deal with the time of charge conference. And so it may turn out you're right, Mr. Herring, but I see no reason to deal with this now until we get farther into this. We hear what the evidence is going to be, and I'll deal with it at the time of the charge conference. So I'm going to deny the summary judgment at this point. Is that everything?
Well, we do have a fraud, no evidence claim, Your Honor. If you need to move on, we can reset that for another hearing. I know you're probably getting behind on your docket today, but we do have a no evidence fraud issue.
I would be inclined to handle that kind of the same way, probably. But Ms. LaBeouf, what do you think?
To address it at the charge conference?
Yeah, just address at the time of charge conference.
I think that's exactly right. I think the judge, I think you probably need to hear the evidence as it comes in, Judge.
Well, let me say
a lot of it and cited it for 10 pages of the response.
I would like, Your Honor, at least one point on the fraud issue to address today then. And that is, the plaintiff has done what plaintiff should do here. She has filed a 450-page response to a no evidence summary judgment, making us look through, including the court, look through 450 pages of evidence to try to find what's there that supports the fraud claim. She has brought a fraud claim against the practice and against Dr. Echt. She had all of her fraud evidence is, we'll talk about this at the charge conference now, I know, is really breach of contract evidence. He says breach of contract, didn't get paid, paid inappropriately. Yes, we can breach a contract without committing fraud. She has submitted no evidence here that there was any intent at the time these contract was entered or these representations were made of, there's no intent to not fulfill that contract or no intent of knowing of fraud. Now, I believe that's true of the practice, but what's certainly true here, Your Honor, and this is what I would like to address today, is this: there's nothing in here, nothing in this 450 pages that addresses Dr. Echt individually. He was there as the practice. He's the owner of the practice. Any meeting he had was with the practice. He didn't sign a contract, but he negotiated the contract on behalf of the practice. All of that is the practice. So if any fraud, which I don't believe there's any fraud here, but if there was, all of this 450 pages is against the practice. There's nothing here about Dr. Echt individually. Now, the plaintiff is going to say, oh, well, Dr. X said X, or oh, Dr. X said Y, or Dr. X said he would pay this. Yes, Dr. X did say those things in behalf of the practice when he was negotiating the contract, when he was meeting with the plaintiff on behalf of the practice. There's no evidence here that he did anything individually, and that's why we moved for summary judgment. No evidence for the practice and for Dr. Echt.
Well, if we're hearing this now, I guess, are we, I just need some guidance, ready to go.
Yeah, I tend to think I'm going to treat this the same way. We'll deal with it at the time of the charge conference. So,
Okay.
The summary judgment at this point is denied. All right, guys, thank you so much. And just get me an order. Ms. LaBeouf, when you submit the order, go ahead and make sure that it says at the beginning that this was heard on August 2nd, 2021. Make sure you share a copy of the order with Mr. Herring before you submit it, and then email it to Rhonda as well as e-filing it, okay?
I have one question, Your Honor. How do we deal in the order with the attorney's fees issue?
I thought we were going to do that through Rule 11 agreement.
Okay, so we don't want the order to address the attorney's fees at all.
You could do an agreed order. I don't mind doing that. I don't feel I can order you to do what I suggested, but I think you both agreed that that made the most sense. And so if you want to do an agreed order on that point, you could do that, or you could do it via Rule 11.
Okay.
I think that makes the most sense.
Either
way is fine. I'll do an agreed order but I'm not going to do a opposed order. I don't want to do it that way. So for the attorney's fees.
We'll work that out. We submitted an order this morning. It just says both motions are denied. I won't submit it to Ms. Pinson until I talk to Walt Herring and he's had a chance to look at it.
And make sure, because the attorney's fees issue needs to be cut out anyway. And so
it's not.
So you need to, and it needs to say this was heard on August 2nd at the beginning. So,
okay.
All right.
I will. Now, Judge, we're set for trial August 24th. We've submitted an agreed continuance. I just want to see if there's any guidance on that. I know at our last hearing, you said you'd move it if we wanted to, but that's soon.
It's an agreed continuance.
Yes, Your Honor. At our last hearing, you had ordered her, allowed the plaintiff to amend her pleading, and you suggested, look, it's amended pleading 40 days before trial. Mr. Herring, if you need a brief continuance. Nicole and I talked, we agreed we'd move this to November 9th. We submitted a Rule 11 agreement to that effect. And Rhonda said, Ms. Pinson said, why don't y'all submit a agreed motion to continue? And we've now done that.
Let me just look at it real quick. Things have changed a little bit since then, but let me see. Wow, we really are behind. Okay, yeah, go ahead and Ronnie, go ahead and print that out. Let me see if I can print it out. I may try to print this out. When did you submit the order?
The order for the continuance?
Yeah.
That was submitted last week, I believe, Your Honor.
I see it right here. Is this it? Okay. Let's see. print that out right now. Okay, here we go. Ron, I'll go ahead and print this out and email it to you, this order.
Thank you, Judge.
Okay, guys, thank you so much.
Thank you, Your Honor.
Appreciate
I
it.
do need to get to the next case. So
Next time. We appreciate it. Thank you.
thank you guys.
Appreciate it.
Okay, I believe the next case is Nelvy versus Strange. Anyone here on that case? Nelvy versus Strange. Anyone here on that case? Anyone here on Bank of America versus Thomas?
Yes, Your Honor. Terry Stewart Mace for Plaintiff Bank of America.
Okay. And you guys have filed a motion to reinstate. What's going on here?
Yes, Your Honor. I think there were some crossed wires on this one. We may not have understood exactly what the court wanted on it. The case was dismissed on April 20th by the court. The defendant has not appeared, has not made an answer. We were in the process of settling it, and we submitted a letter on April 16th indicating that we had settled it. We also had an attorney appear on that date to announce settlement and request additional time. And this is where I think the wires were crossed. I think you apparently expected it to be submitted in the next day or so. And we did not submit it in the next day. I actually received it on the day that the order was signed dismissing it. That agreed judgment is attached to our motion, Your Honor, as an exhibit. We are within the time of that the court has plenary power as of tomorrow. And we are just asking that be reinstated and that the agreed judgment be entered by the court.
Okay. That's no problem. I'll go ahead and reinstate it. So what exactly needs to happen at this point? Does it need to be set for trial or?
No, there is an agreed judgment that is signed by all parties that it was submitted as an exhibit, but it's not, I don't believe it was file stamped because it had an exhibit page over it, or I can resubmit the agreed judgment, Your Honor, for your signature, for your review and signature.
Okay. I don't mind either way. For some reason, my system isn't allowing me to print this order. I'm not sure why that is.
I'll resubmit it to Ms. Pinson directly. Would that be helpful?
Rhonda, why don't you do this? It's really important. Put urgent on this, Rhonda. I will sign this tomorrow. Go ahead and email her also the agreed judgment and the same thing. Rhonda, put this as urgent and make sure that I sign this tomorrow because it's the last day I can sign it. Okay, Rhonda? Can you text me and make sure that's okay? Okay. All right. Not sure why I can't print this out, but my system.
That's okay. I'll get another one to you, Your Honor.
Okay. All right. Thank you so much. You be safe.
Thank
Okay?
you. Thank you. May I be excused?
You may.
Thank you. Have a great day.
You too.
Thank you.
Jimenez versus Sarala. Anyone here on that case?
Yes, good morning, Your Honor. It's Colin Hatcher appearing for defendant Lauren Srala.
Anyone here for the plaintiff? Where's the plaintiff here? Okay, go ahead and proceed.
Your Honor, this is a no evidence motion for summary judgment. The plaintiff has not responded, and Your Honor, we've been unable to reach the plaintiff. The motion and the notice of motion were properly served, and they were returned with a return to sender. Addressee has moved, no following address known. So, Your Honor, we have no way to contact the plaintiff, as the only address we have is the one that was returned. So in response to our motion, we have no response from the plaintiff. And I don't believe the court has any information either, Your Honor, on any new address for the plaintiff. Your Honor, given the plaintiff hasn't responded, I would ask the court to grant the motion.
Court will grant the motion. I don't know why this isn't printing. I'm having some issues with printing right now. This is not what I wanted. Let's see. Let me see if it'll print now. Okay. Okay, Rhonda, this isn't printing either. I don't know why. I thought this was fixed. So can you go ahead and print out its, let me share screen it, Rhonda, so you can see what I'm talking about. It's this order right here, if you don't mind printing this out. Let me see if this will print. Nope, okay, it's not. So Rhonda, go ahead and print this order out if you don't mind. Okay, sir, you are excused. Thank you so much.
Thank you very much, Your Honor. Have a good day.
You too. Our next hearing is on Fulling versus Baylor, Scott and White. Anyone here on that case? The scheduling conference.
Rodney Gappelberg is here for the plaintiff.
And Nicole Tong here on behalf of the Baylor defendant.
Okay, when do you guys want to set this for trial?
Your Honor, we have a motion to transfer venue that's set for September 10th. My client's more than happy to enter an agreed scheduling order, setting it for trial once that's been heard and ruled upon. It's just, I did a search and I couldn't find anything saying definitively that they wouldn't waive the motion to transfer venue by entering an ASO before then. And so that's really the only thing holding this up.
Why don't we just do this? Let's pick a date and we'll go ahead and set it for trial, and then you guys can enter an ASO if I deny the transfer. How about that?
Okay, sure.
So when would you guys like to, when would you like to set it for trial, understanding that it's subject to the transfer?
Your Honor, we had proposed something late winter, early spring, since we haven't yet been able to start discovery, but that may be a little early with the lockdown that's happening.
Yeah, that's very early. Unless you mean 2022. Do you mean fall of 2022 or when would you like?
Fall of 2022 is agreeable to defendant.
We'll work with the court. If fall of 22 is available, yes.
I don't care, honestly. If any time after the summer is fine with me, or in the summer or later.
On the code,
I would say the September, October timeframe of 2022 is sounds good to me.
well, let's try September.
Okay, let's see. September 2022. So we've got the 6th, the 13th, the 20th, or the 22nd, 27th.
6 looks fine to me, Your Honor.
That's right after Labor Day, just FYI.
Oh,
Yeah.
how about the 20? What was the next available date, Judge?
The 13th, the 20th, or the 27th.
How about the 13th?
That's fine with me.
Okay, let's go ahead and set it for the 13th.
Or Nicole, do you think we'll have any trouble selecting a mediator, or do you want to talk to the
Oh,
judge about appointing?
Pick a mediator.
Most anybody at Burden is fine with me, and or Beth Krugler over in Fort Worth. We've had some luck with her and medical or quasi-medical negligence cases, which this one sort of is. It's really a slip and fall, Judge, but not sure what to call it. But
I'd propose Karen Gammon, or I'm agreeable to anyone from Gammon Mediations.
Gammon Mediations, okay.
did you say
Any of those?
Burden?
No, she said Gammon.
Gammon.
I'm okay with Gammon. I'm okay with Burden.
I don't think we'll have any problem.
Let's get it resolved. So is there, I don't know who else is at Gammon right now. Who else is at Gammon?
It might just be her.
I
But there
thought
is
she
one.
hired another mediator, but I don't remember the name. But I don't remember. I met this person before the pandemic. I don't know if she's still there.
How about Ken Rubenstein over at Burden?
He's a great mediator. What do y'all think?
That's fine. That's fine.
All right, let's go ahead and appoint Ken. So Rhonda, go ahead and appoint Ken Rubenstein, and we'll go from there. Anything else, guys?
No,
I believe so, Judge.
You guys be safe, okay? And just once the transfer is done, you guys can submit an agreed scheduling order. If there's an issue, just let me know.
Thank you, Your Honor.
Thank you, Your Honor.
You guys be safe. All right, busy morning. What do we have next? Okay. Mr. Brenning, what are you here for, sir?
Yes, Your Honor, we are here for the discovery hearing. We are requesting further discovery.
Which case?
This is Harris versus SB Premium.
Okay. All right, you guys are a little bit early, so let me go ahead, and I'm going to take a quick break and chat with my interns, go off YouTube, and then we'll get started. We finally caught up. Anyone here on the dismissal docket that I haven't talked to yet?